Welcome to this overview of trade secret law. I'm Professor Seth C. Oranburg from the University of New Hampshire Franklin Pierce School of Law, and over the course of 5 videos, we are going to cover the basics of trade secret law. Our 5 videos will include introduction to trade secret law, explaining why it exists and how to understand it generally. We're going to define what is a trade secret under American law. We're going to understand when a trade secret is misappropriated under trade secret law in America. We're going to evaluate how to protect trade secrets with contractual arrangements, and we're going to discuss what remedies are available for parties whose trade secrets have been misappropriated. So stay tuned for this 5-video series, and at the end of it, you should have a basic fundamental understanding of how trade secret law works. Remedies for trade secret violations. Trade secret remedies are quite broad. Courts have many tools at their disposal to remedy trade secret misappropriations. The 2 main categories of remedies available to private plaintiffs under civil law are injunctions and money damages. An injunction is a judicial process that requires a party to do or not to do a particular thing. In other words, an injunction is a court order requiring a person or entity to take or cease taking a specific action. An injunction which prohibits specified conduct is called a prohibitory injunction. An injunction which requires the performance of a specified act is called a mandatory injunction. Either or both can be granted in trade secrets cases. Money damages are the requirement of the defendant to pay money to the plaintiff. Money damages for trade secret misappropriations are typically calculated by either, first, the plaintiff's harm from the misappropriation plus the defendant's ill-gotten gain from it, or second, a reasonable royalty fee, as if the defendant had licensed the trade secret from the plaintiff in the first place. These remedies come up at different times in the procedure of civil litigation. Pre-trial remedies tend to address ongoing harms through injunctions that stop the harms from piling up. Post-trial remedies tend to address past harms or prevent future ones. These pre-trial remedies are available to a private plaintiff under civil law and include a temporary restraining order, a preliminary injunction, and, in federal cases under the Defend Trade Secrets Act, ex parte civil seizure. A temporary restraining order, or TRO, is designed to prevent immediate and irreparable harm by maintaining the status quo, because once a secret is out, its value can be destroyed. So while the case is pending before there is time for any hearing on the matter, a TRO can be requested by one of the parties, so-called ex parte, meaning without a hearing, without the other party present, directly from the judge. And the judge can grant the plaintiff the temporary restraining order without an opportunity for response by the defense. And for that reason, it's limited in time until there can be a hearing on a preliminary injunction. A preliminary injunction is also granted while a case is pending, but it requires the other party having notice and an opportunity to be heard. To merit a preliminary injunction, a party seeking the preliminary injunction must, at a hearing, demonstrate a clearly ascertained right that's in need of protection, irreparable injury in the absence of an injunction, that no remedy at law, no money damages, would be adequate to address the harm, and that there is a likelihood of success on the merits in a full trial. The standard for meriting a preliminary injunction is, by the way, the same basically as getting a temporary restraining order, but it's typically harder for a plaintiff to win a preliminary injunction because then the defendant has an opportunity to present counterarguments at a hearing, whereas a temporary restraining order may be conducted ex parte. Under federal law, a claim under the Defend Trade Secrets Act may also have the possibility of a ex parte civil seizure under extraordinary circumstances, where the plaintiff has made a federal claim under the DTSA. Courts are authorized to issue an order providing the seizure of property necessary to prevent the propagation or dissemination of the trade secret that is the subject of the action. This extraordinary remedy requires the plaintiff to prove 8 elements. First, a temporary restraining order would be inadequate. Second, immediate and irreparable injury will occur if the seizure is not ordered. Third, harm to the applicant from denying the petition outweighs harm to the defendant from granting it. Fourth, that the applicant is likely to succeed on the merits in a misappropriation lawsuit against the person against whom seizure is sought. Fifth, the person against whom seizure is sought has actual possession of the secret and the property to be seized. Sixth, the applicant adequately describes the matter to be seized and its location. Seventh, the person against whom seizure is sought would destroy, move, hide, or otherwise make such matter inaccessible to the court if the applicant were to provide notice. And eighth, the applicant has not publicized the requested seizure. Post-trial remedies generally address past or future harms, whereas the pretrial remedies deal with ongoing harms. In general, courts use permanent injunctions to address future harms by preventing the misappropriation from continuing into the future, whereas money damages address past harms by looking back at what the plaintiff lost and the defendant gained from the misappropriation that already occurred. A permanent injunction addresses future harms by giving a trade secret holder a chance to catch up with the misappropriator, so the misappropriator does not gain any long-term benefit from their wrongdoing. This so-called permanent injunction is not really permanent. It lasts typically for a specified time with an expiration date, and even if it doesn't have an expiration date, a permanent injunction regarding a trade secret lasts only as long as the trade secret is a trade secret. Trade secrets generally do not last forever, so the term permanent can be a bit misleading in these cases. The purpose of the permanent injunction is to give the trade secret holder a head start over the misappropriator before competition begins in earnest. The purpose is not to prevent competition in perpetuity, and so it will be limited in time. The legal elements a plaintiff must show to merit a permanent injunction are, first, that the plaintiff has suffered irreparable injury from the defendant's misappropriation of the trade secret, which could be loss of a unique product, loss of goodwill, or loss of a competitive market position. Second, that money damages are inadequate to compensate for that irreparable injury, perhaps because money damages are hard or impossible to calculate. Third, that the equities, fairness, balance in favor of a permanent injunction. And relatedly, fourth, the hardship the plaintiff would face if the injunction is not granted outweighs the hardship the defendant would face if the injunction is granted. And fifth, looking at the equities in general, we ask whether the injunction is in the public interest. An injunction is not in the public interest if that injunction gives the plaintiff a monopoly position from which the plaintiff could extract monopoly rents from the public. A court may grant both money damages and injunctive remedies in civil cases for trade secret misappropriation. In addition, a court can award punitive damages and attorney's fees. The standard for punitive damages requires willful and malicious misappropriation. Courts don't agree on exactly what this means, and juries award them in about 2% of cases. The standard for attorney's fees requires bad faith tactics in trade secret litigation or willful and malicious misappropriation. That said, they're not granted all that often. Less than 1% of cases end up granting attorney's fees. Criminal penalties are also available for flagrant trade secret misappropriations. Remember, only states can seek criminal penalties. Moreover, most states have adopted a penal code, and there is no criminal common law of trade secret misappropriation. So, in general, specific statutes must be brought to bear to make particular conduct illegal. I'm going to offer a selection of criminal penalties that can be related to trade secret misappropriations, but this is neither an exhaustive list, nor do these penalties apply in all jurisdictions. But just to give you some idea of crimes that can also relate to trade secrets, we have theft, receiving stolen property, unauthorized access to computers, economic espionage, computer crimes, mail or wire fraud, racketeering, influence, and corrupt organizations crimes, violations of the National Stolen Property Act, and fraud in connection with access devices. Keep in mind that only governments can charge alleged perpetrators for crimes. In order to seek criminal remedies, the trade secret holder must therefore enlist the state's support. Governmental prosecutors have what's called prosecutorial discretion. They don't have to take every case that's presented to them. So if the state does not want to prosecute that particular crime, that remedy won't be available. If the state does not take, if the state does take the criminal case, then the would-be plaintiff typically loses control of the litigation, and there may be delays, as civil litigation is often stayed pending some criminal investigation. This concludes the series on trade secret law. We learned what is a trade secret, when a trade secret is misappropriated, how to protect trade secrets through contracts, and what are remedies for trade secret misappropriation. I hope this information helps you get started with trade secret law.